The matter before the court is York 24218, Katrina Welch versus Naomi Chavaree, and we are being streamed live on the web. I would ask counsel to introduce yourselves by saying your names for the record, together with the party you represent, starting with the appellant.
Attorney Brittany Sawyer. I represent Ms. Welch, the appellant.
Gregory Orso, represent Naomi Chavaree, the appellee.
Thank you. And Ms. Sawyer, if you're ready to proceed, we'd be happy to hear your argument.
May it please the court, Chief Justice Stanfill and members of the court. I represent Ms. Welch. Ms. Welch lived with Ms. Chavaree and their daughter Cordelia for the first 3 years of her life. She moved in with Ms. Chavaree prior to her giving birth and was an active part in the pregnancy as well as the birth of Cordelia. She played an active parental role while the parties resided together and after they separated. When the parties separated in 2020, Ms. Welch continued to have weekly overnight visitation with Cordelia, just as any parent would after a separation. This continued for approximately 3 years, until Ms. Chavaree decided to move with Cordelia to upstate Maine and indicated to Ms. Welch that she would no longer be allowing visitation to occur. At that time, Ms. Welch filed her complaint for de facto parentage. It is our position that the court erred in denying her standing to proceed with her complaint without holding a hearing because there were disputed facts between the two affidavits. The court abused its discretion when it declined to hold the hearing because those facts that are disputed were material to this case. Furthermore, the facts in Ms. Welch's affidavit could have led to a finding that she had standing. We would ask the court to vacate the order and remand this case for hearing. I'm happy to take questions at this point.
Haven't we said that it is in the discretion of the trial judge whether to hold a hearing?
It is in the statute at the discretion of the trial judge, but the court has said that then when there are material disputed facts that a hearing should be held to make a determination of those.
So that's the standard you're positing. If there are disputes between the affidavits, there ought to be a hearing, period.
Yes.
I noticed in the affidavit that there are a lot of sort of conclusory statements. I was highly involved, continued to co-parent, and then there are some facts to follow there, but what are we to take from the conclusory statements? Can a person simply say, we'll go down the checklist and just take the statutory language? Would that be sufficient without facts? Just to state conclusorily, I've been involved in, I've resided with the child for a significant period of time, I've engaged in consistent caretaking and a bonded and dependent relationship, et cetera, just citing the language of the statute. That wouldn't be enough, would it?
Solely stating the statute I don't think is enough, but under the affidavit that Ms. Welch filed, I believe there are additional facts related specifically to her caretaking of Cordelia.
And what facts in the affidavit take it above just a normal, interested person living in the household doing the things they would do? Is there anything in there that really needs to be flagged that is demonstrative of the fact that you have met this burden of showing at this point?
So I believe under her affidavit, she listed that she was on all the school paperwork for the child. She was involved with medical appointments as well as extracurricular activities. She had taken
Let me just say, involved in medical appointments, I mean, that's, again, getting back to the conclusory nature. I suppose if someone, drove the child to the doctor and home again, they would be involved in medical appointments. But I'm just wondering how deep you feel you need to go. Was involvement, making decisions on medication, consulting with the doctor, things like that? Those are the kind of meaty details that would need to flesh out whether the statutory conditions are met.
Well, I think solely alone saying you take a child to a medical appointment is probably not going to rise to the level of a de facto parent. But I think taking all the facts together in her affidavit would show that here.
One of the elements is that the relationship was fostered or supported by the other parent. and that the other parent understood, acknowledged, or accepted, or behaved as though your client were the parent of the child. I mean, are those facts alleged in this affidavit?
I believe so, for the fact that even after the separation, my client continued to have weekly visitation with the child. I think that's above and beyond, a support in the child's life. That's a very consistent contact schedule, as well as having her listed as a parent on school paperwork, which my client notes down. I mean, that's a pretty big step right there.
Again, it's sort of a summary statement. I have a bonded, independent relationship with the child, and mother has accepted me as the other mother parent. Again, that would be like the subject, first sentence in a paragraph, and saying, she said to me, hey, we're equal, even Steven on this, you are doing the same role I am, but just saying that the mother has accepted me as a co-equal without the facts there doesn't have the same persuasive weight as facts that, she's actually said. There can be acceptance by acquiescence, which I guess is what you're getting at here. But it looks by the fact that there's no express acknowledgement that maybe there never was an express acknowledgement. Can we assume that or infer that?
So I think there's been both scenarios in this case of the implicit acts that amount to my client acting as a parent, as well as I believe there was a statement in the appellee's affidavit that she did intend for Cordelia to have a relationship with Miss Welch and remain involved because of the relationship they had had when they were together.
So should we look at situations involving de facto parenting in the similar or a different way when a grandparent is asking for a de facto parentage? We're trying to say, well, is this what a grandparent would normally do, or is this more than that? When it's someone who has a romantic relationship with someone and then that romantic relationship terminates, do we say, well, is this greater than the average girlfriend would be? Or how do we adjust our analysis in that different scenario?
So I don't think it's necessarily a distinction between a grandparent and a significant other per se. I think it's going to depend on the facts of the case and the grandparent's
I mean, you're not going to have
involvement.
a relative, a relationship like you're a relative if you're not a relative. So, and that's the situation here. So that I'm trying to get my head around what it is we're supposed to, what are the markers that show that she was treated like a relative? So is that enough? If she's called parent, if her parents are called Gaga, Nana, and that's showing that you're essentially treating her like she was a parent to the child.
Right. I think that those are some of the elements we have to look at, because I'm sure there are significant others out there who live with their partner and a child who maybe don't have a parental role, that aren't on school paperwork, that aren't going to doctor's appointments, that aren't financially supporting a child and having that parent-child relationship.
Well, there is a fundamental difference, isn't there, between a grandparent and a significant other? I mean, the significant other is functioning almost by definition more like a parent.
Right, a significant other is probably more akin to a step-parent than a grandmother because the circumstances there.
In reviewing the affidavit from Ms. Chavaree, it frankly, most of what it has to do with, it seemed to me, was best interest. Does there even need to be a hearing on standing, or should it just go to the hearing on the merits?
I mean, I think we'd have to return to have a hearing on standing. But I think that the parties, when I can look at the different affidavits, have a different view of what the best interest of the child may be here.
But best interest is not the issue for standing, it's the issue for
The final hearing on the merits.
What contact, if any, should be had is an issue that is on the table in the best interest of the child after de facto parentage is established.
That is right.
Can I clarify that? In order to satisfy the standing requirement, isn't it your burden to show, at least by prima facie evidence, that you tick off all of the boxes, all 5 of the factors in the statute, including the best interest factor?
Yes, that is correct. All the factors have to be met.
Now, here, the trial judge focused on one of the factors only, didn't really address the others. So why wouldn't it make sense, just talking kind of theoretically here, about the need for a separate hearing on standing? Now, I understand our jurisprudence, and I understand the statute says if there are disputes between the affidavits that involve material facts, then you go to have a hearing on standing. But the whole purpose of standing is really to weed out claims that are almost frivolous, that infringe upon a parent's, the other parent's fundamental liberty interests. But by having a standing hearing, separate from a merits hearing, you're putting that parent potentially through 2 separate hearings. I mean, that's a double infringement, so to speak. So just talking generally, why doesn't it make sense in close cases to consolidate those into one hearing?
I think it could make sense, and I think looking at the facts of this case, thinking about who you might call for a hearing on standing versus on the merits, that second hearing after, they would essentially be the same hearing. Under the statute, there's different standards being looked at, because I believe at the merits hearing, we go to a clear and convincing level. But it really is the same hearing, and it would certainly save on judicial time and attorney's fees and things like that to have one hearing.
Going back to the affidavit just one more time, on the subject, which usually is a challenging one, these, that the person and the other parent have understood, acknowledged, or accepted or behaved that the person is a parent of the child. I think one of the strongest allegations in the affidavit is that your client says, I am listed on her school paperwork as a parent. And again, that's sort of written sort of in the passive. I don't know whether someone can go to the school and say, hi, I'm so-and-so's partner, I want to be listed as a parent, and then the school writes it down, or whether the mother goes to school and says, she's a mother too. That would be powerful one way or the other. It would be helpful if that fact had been fleshed out rather than just stating it sort of in the passive. And you can't tell us here today because it's not a matter of record. I'm just saying that as far as the affidavit went, it just sort of leaves a bit of a question mark lingering in the air. I guess I've asked you a question that you can't answer, so I apologize for that. But just a factor. I'm trying to look at this as the judge would look at it in the first instance.
I mean, in my experience, someone can't generally go to the school and say, I want to be added in as a parent without some sort of proof there. Usually I see, the paperwork goes home with the child, and a parent would fill that out and put in who they feel is necessary on the paperwork.
Don't appear to be additional questions. Thank you.
Thank you.
Good afternoon. May it please the court, my name is Gregory
Orso,
Orso.
I note that the green light is already on.
Yeah, I'm good, so
Okay.
fire away.
All right. So in reviewing your client's affidavit, I was struck by the fact that she's talking almost exclusively about how things are now, as opposed to how the relationship was established. And in fact, in paragraphs 36, 37, she concedes that the plaintiff was residing with her and her daughter from a month after birth through January 21, and that visits and overnights continued after separation. I mean, isn't that a really key? There may be an issue as to what contact is in best interest, but that's clearly disputed, and clearly your client doesn't think continuing contact is. But hasn't she essentially conceded all of the other things that were in the plaintiff's affidavit?
I would suggest that she hasn't, and here is the thing. If you look at this court's case law, and you look at the facts behind whether this court has upheld or remanded back for a hearing on the issue of standing, I don't believe this case matches up. The living together, again, what we're going to have here is any situation where you have a committed relationship, and I don't have any doubt to believe this was a committed relationship for a couple of years, you are going to have the circumstances surrounding what she did, the fact that she lived together, the fact that there was some care provided. This court itself has identified a very important point in the court correctly drew the proper distinction, which can be nuanced and subtle, between the role of a nurturing involved caregiver and one who acts as a parent. And I think that's where this case turns, where the rubber meets the road here.
Well,
is that
isn't it pretty compelling if she's called a parent in the school work material and her relatives are called Nana and Gaga?
I would suggest to the court that it's very rare that I'm allowed to use the school records because of them not being necessarily the most accurate presentation of whether or not a parent is there or not.
But it's at least evidence of it.
It could be evidence of it. I wouldn't say that it could be evidence of that, certainly. However,
Well, do you have any instance in which a parent who is not the biological parent of the child gets added to school records and identified as a parent?
well, I've had, not that I'm going to be able to bring it factually here, but I've raised 4 kids in the New York school system, and I have people, my brother lives in town, is identified as somebody that has equal status as me and my wife to pick them up.
But you didn't call him a parent, did you?
I can't tell you what was on the form. They were identified as a person that has rights that could pick up my child.
Sounds like we need a hearing.
Well, I don't think you need a hearing on this. I think that would go against what this court has done in the last 5 years.
Well, if you have a circumstance in which an individual has indicated in an affidavit under oath that they have provided financial support for a person, and going beyond the circumstances,
Sure.
you talked about 2 individuals living together
Yeah.
in a relationship, all sorts of things can happen. But going the extra mile and saying, I've provided financial support for this child in this circumstance,
Sure.
doesn't that take you beyond what you described?
I would suggest to you, Justice Lawrence, that the reality of living in Maine in the 21st century is that there are plenty of people, grandparents, relatives, other people providing financial support for kids, that they don't have a parental role.
But that's different, counsel, than someone who is living in as a significant other on a day-to-day basis in the nature of a parent, isn't it?
Well, I would say it's not in the nature of a parent, Your Honor. It is sharing expenses.
Well, no, this is more than, there are, granted, Justice Meade made a good point that this is pretty general in terms of the descriptions of the roles, but we have a fact that this couple lived together for 3 years prior to the birth of the child. The appellant was present for the birth of the child, remained there for 3 years. Obviously, there are some facts here which are asserted that suggest pretty clearly that there was a connection between the child and the parent. Standing's a pretty low bar, isn't it? And if those facts are at least asserted, that normally would get you through the door unless there's a counter affidavit, and we have a counter affidavit here. Why shouldn't there at least be a hearing to flesh this out a little further?
Because it's an abuse of discretion standard, and we give trial courts who look through all the evidence not only the ability to make that decision, but also the precedent that this court has set. And I would suggest to you in the last 5 years, whether it's Ray Child, Philip S., Libby Estabrook, Martin versus McMahon, Davis McGuire, all of these cases have facts that are well in excess. Whether you go to the Martin and McMahon 2 years ago, it talks about one of the good friends of the parents, abdication of parental roles. And that's not what happened here. This is not a situation where somebody abdicated.
Your client doesn't have to abdicate the parent. I mean, when you have 2 parents, biological parents of a
Sure.
child, one doesn't get parental rights because the other abdicates. I mean, they can both have parental rights.
Well, no, but what we're talking about here is that situation, that child had 2 parents and somebody else came in as a de facto parent and essentially did all the parenting. This isn't a situation that's happened here. This person did somewhat of parenting as a byproduct of having a relationship with somebody who has a child. Opening up that door and creating that low level of standing would obviously, I believe, go against the case law of this court of the last 5 years, but also would create a firestorm in the court system for all of these cases meeting standing.
But
Now we're
as
having-
we look at the affidavits here, I mean, there's affidavits on both sides. I mean, it's hard to believe they're talking about the same situation here. It's very contested on almost every point. And the judge, obviously, you get to a point, well, we've said this out loud, where the standing determination will rest on the resolution of material facts that the parties have disputed in their affidavits. A hearing will be necessary to allow the court to evaluate the evidence in order to adjudicate those facts. So we get them going toe-to-toe, head-to-head, A, B, contra. The hearing is the only way the judge can listen to both sides and decide, okay, I accept this credibility, that one I don't.
I would disagree with my co-counsel in the sense that it has to be disputed material facts, not just disputed facts, number one. Number two, I think it's important we recognize that
But
we're
I
talking...
guess, are you saying that, I mean, in this case, your client doesn't dispute that they lived together for the...
No.
Let me finish. They lived together for the period of time alleged by the plaintiff, but also that after they split up, the child continued to have visitation and visit with and stay with, on a fairly regular basis, the plaintiff.
At the discretion of my client.
Well, it may be at her discretion, but it occurred for quite a long period of time.
My client also had other people provide daycare, other things that happen during a typical child's life when you have a single parent. This was part of it. And it would be, again, that single parent is sort of a double-edged sword, whatever they do. If they don't allow any contact, and this child has some affinity or affection for this parent, which again is not the standard, they can have affection for somebody, it doesn't mean they get a standing hearing. But if that child has affection for somebody that they see somewhat frequently, why would we encourage single parents to take that person out of that child's life? I think what she did should be applauded as opposed to being used against her for purposes of creating standing and infringing upon her constitutional rights.
You cited our precedent, but in Young and Libby, wasn't it really important that the child, the one parent allowed the other child to call the other one a parent, treated her as a parent, and the relatives were called Pop, and all the relatives of that other person were treated like family?
Absolutely, and they were together 6 to 7 years. They lived together. Number one. Number two, that situation, that child was on their health insurance. There are a bunch of facts that, again, I think all the case law in the last 5 years from this court, this case pales in comparison with regard to the facts. It can be pretty pale to be prima facie evidence. You don't need to have concrete preponderance. No question about that. That's why I think we leave it up to the trial court, and I don't believe this is an abuse of discretion.
Let me ask you this. I mean, I think in your brief in particular, you did mention the period of time, and that this was, you seem to take the position that the time with which they lived together wasn't long enough. And I'm going to ask you about the presumed parentage. So our legislature has already said under Section 1881 that a person is presumed to be a parent of a child if the person resided in the same household with the child and openly held out the child as the person's own from the time the child was born and for a period of at least 2 years thereafter. Now, in this case, it appears both from the allegations of the plaintiff and from your defense, from your clients, that they didn't move in together until a month after the child was born. But given that statute, had they moved in together a month earlier, that would be the end of the story. She would be presumed to be a parent.
Well, yeah, I don't want to comment on the whether or not that sounds like a good decision by the legislature or not. But the reality is, I think that is more for
Well, whether it's a good decision or not, doesn't it go sort of way against the idea that, the amount of time they lived together, which was almost 3 years, at an early point in this child's life?
Sure.
That is, in fact, significant.
That is a factor that could be significant in this case if, in fact, the court were to look at the other factors and say, okay, well, that's the one factor that weighs in favor of standing, but the other factors don't. It's one of a dozen factors in this case that would be applicable, and why we leave it up to the discretion of the trial court.
But the court didn't look at those other factors. The court only focused on this one factor, and that was after a request for further findings.
I think the court looked at all the factors, Your Honor, but the court focused on what was necessary to determine whether or not it met all the factors. A trial court looking at 5 factors, if it doesn't meet one, it's not going forward to a hearing.
Ultimately, this statute, the Parentage Act, is a child-focused, child-oriented statute. Granted, parents have fundamental, important constitutional rights, but ultimately, bottom line, shouldn't courts be really zeroing in on, focusing on what's best for this child? And standing is an important screening process. It's an important preliminary step. But ultimately, shouldn't the courts be looking at how does this best serve the child?
I think the fundamental problem there is that then opens the trial courts, the district court, the overrun district court already, up to open to litigation that will involve a neighbor next door. That'll involve someone down the street who takes the kid once a week because they have a good relationship, to any relative that decides that these parents are not fit, which happens every day in this district court, that these parents are not fit. We are going to now allow us to have standing to have a hearing. And what that does is that takes rights away from us as parents.
I agree with you, the neighbor next door or the relative who comes over once a month, that they're in a different category. We're talking here about people who lived together for 3 years and raised this child.
Sure, but we're also talking about, for example, this court in 2020, who had an aunt and uncle that essentially did much more than is alleged here. And this court upheld the decision to not allow standing because they were not making parenting decisions. And I think that's where there's a distinction. This was never intended to be a parent. This was not a person who met the criteria to be a parent. What this was a nurturing caregiver.
Well, there's a dispute based on the affidavits as to what the intentions were.
Well, I think for purposes of what somebody's intentions are, I don't think necessarily. I think that has to be shown by some level of proof as opposed to a summary statement in an affidavit.
Does that mean that the proof has to be in the nature of the legal or biological parent giving some level of parental decision-making authority to the other party, the proposed de facto parent?
It would seem to me that that would be an indicator of meeting that criterion. But I don't think that's the only way it could be done. But I would think there would have to be some discussions. It's, again, having raised 4 kids, the discussions you have with the other parent of these children, these are not the discussions these parties had. The discussions these parties had were day-to-day things that have to do with our schedules because we live together. And we shouldn't discourage that. We should not discourage somebody, a partner, taking a child to a doctor's appointment.
So are you
but that
saying
does
that
not
there
give them
has to
rights.
be an explicit discussion saying, I agree and am granting you parental rights, and without that, it can't?
I don't think it goes to that level. I don't think you have to go that
Isn't that what
extreme.
happens in most cases, is people just sort of slide into it? You know, we have a kiddo.
Absolutely, and that's why in the case Libby, where there's 6 or 7 years, you slide into it. A couple of years, I don't believe you do.
Well, we were at more than a couple of years here.
Well, we're at 2 years and 8 months, technically, with the
Living
time frame that
together
both
plus
parties.
continued contact and visitation thereafter.
And again, I don't think we want to discourage that.
At the trial court level, was there, did the court decide this only on the papers, or was there actually a hearing?
There was not a hearing, Your Honor.
So we've probably heard more today.
You've heard. You're the only one that heard anything.
We've heard more today about the situation on the ground, so to speak, than the trial court did.
No question about that. But again, this law court has said time and time again, having a hearing takes rights away from me as a parent.
Thank you, counsel.
Thank you, Your Honor.
Ms. Sawyer, I believe you reserved 2 minutes for rebuttal.
Yes, I just want to touch base briefly on the concern of a flurry of influx of petitions or people getting standing. I don't see that as a concern under this statute currently, as the first prong is that you have to have resided together for a significant period of time. So the neighbor who does occasional daycare, I don't think is getting past this point if they even tried to do something like that. I also wanted to touch base on the fact that, yes, this was only based on the affidavits, the complaint, the affidavits, and then a motion for further findings. There was never a status conference, a case management conference, a hearing of any kind in the district court to get any more information out of either party.
What evidence is there that your client did more than what I'll say a grandparent might do. In other words, take a child to the doctor, pick the child up at school, have the child over for visits at home, at the grandparent's home, et cetera.
So, I mean, that might depend on what grandparent you're talking about in each situation.
Actively involved grandparents.
But I don't think a grandparent is living in the house most of the time, you know, day in, day out, getting up at night when the child is an infant to change their diaper and feed them, and then as they get older, help select childcare and talk about what kind of activities they're gonna do and be on the school paperwork and be involved in these medical appointments. And then a continuing visitation schedule. Your average grandparent, I don't think, has, you know, an ongoing contact schedule on a weekly basis.
There don't appear to be additional questions. Thank you.
Thank you.
Thank you, counsel, for the arguments in this case. As is our usual practice, we will take the matter under advisement. We'll issue a decision in due course, and with that, we'll be in recess on this matter.
All rise.